We wanted to draw your attention to section 85, 2 and 3. 2 says that a person who is claiming excluded property is responsible for having the evidence to make that case. In the example of the house above, your child would be responsible for proving that she paid $1 million for the house and that this payment came from an asset that she owned prior to the relationship. If she can't prove that, then she would lose the exclusion. This would mean that instead of $1.25 million, she would only receive $750,000. This is why so much of what we will be focusing on today is the evidence that you need to provide regarding the funds you're providing to your child. But this isn't CSI, and the courts are not looking for evidence beyond a reasonable doubt. They're looking to prove it on the balance of probabilities. She, a 2017 Court of Appeal case, tells us that it doesn't have to be done with mathematical certainty. The evidence, however, must be clear and cogent. During a long relationship, documents can sometimes be destroyed and memories dim. So if there aren't documents, you're able to testify before the court to tell the court what happened. And the court is allowed to draw a reasonable inference from what occurred. So if there was a transaction years and years ago and the documents have been lost, that doesn't necessarily mean that you've lost your exclusion, but it does mean that it'll be significantly harder. So Section 85(3) is new, and us family lawyers like it because it clears up ambiguity that has crept into the law. What it means is that if your child, madly in love with her new partner and blind to reason, decides inexplicably to put the house into joint names, she doesn't lose her exclusion. So that's good news for us today.